Good evening, everyone. The DUI guy is back. This time, me and my beanie, by the way. This time, I want to welcome you to a very, very special episode. First of all, this will be the first of many. You all voted, I listened. We are going to start streaming these at 8 o'clock on Sundays, 8 p.m. Eastern time. I will have Eric Brandt joining us later on in the stream. And I also wanted to show you all my best friend in the whole wide world. Her name is Beady, and she is my princess. So she's going to be with us the entire stream. Unfortunately, you won't be able to see her because she's going to be on my lap. However, I want you all to know that she's with us in spirit. So, yes, it is the Taco Bell dog. She's a Chihuahua, purebred. Anyway, so a few updates before we begin, as always. Thank you all so much, by the way. I'm almost, my channel is almost at 4,000 subs. I think I'm about 250 short. So I should reach that goal probably Thursday or Friday, maybe of this week. I also know that this is going to be restreamed, as I've learned. My previous stream on First Amendment auditors has been restreamed by several agencies and groups. So I'm presuming this is also being restreamed. So hello, all you restreamers and restreamees. I'm not sure. I'm good at making up words. I was a philosophy major. Anyway, also want to thank you all for 1 million woohoo views. I hit that on February 22nd. I guess I missed it. So we're almost halfway to 1.5 million views. Also, just a quick update. I should have enough material to continue uploading daily, definitely for the month of March. Now, I will eventually start running out of fresh new material. We'll see how it goes because I have trials set. My next trial is in April, so I will not have any new trials unless I pick up a brand new case that is going to trial sooner until April or May. And then I have a lot set. Not sure if they will all go or not, but as I see that I will eventually start running out of material, I will have to begin uploading maybe once every couple of days, maybe every other day, something like that. So it will slow down. Just be on the lookout for that. But for now, we're still continuing in the same fashion of one upload every day at 8 a.m. Eastern. All right, so that's some housekeeping items out of the way. Caveats for this video. We are talking about a very sensitive topic in our judicial system, which is jury nullification. Okay. Yes, I'm an attorney. Yes, I have a license. Yes, I have been practicing for 6 years. But I am in no way, shape, or form an expert on juries or jury nullification. Now, I have personally tried 13 cases. 12 of those I was first chair. Actually, I guess it was 14 because 2 of those I was second chair and 12 of those I was first chair, and 4 bench trials. So that's my personal track record. All 4 bench trials I was lead counsel. Now, all of them, 100% of those, 17, 18, whatever it is, have all been criminal cases, okay? I've only had about 3 or 4 civil cases in my entire career, and most of those have never seen the inside of a courtroom, or if they did, very briefly, and they never got. I have 1 civil case set for jury trial in May. So I don't have any experience in the civil arena, or as much as I would like. So the concept of jury nullification will apply universally, of course. It's not just criminal cases, it's civil cases as well. So I will not be able to speak to that pretty much at all because I don't have personal experience. I've read about it very briefly, and I realize it's just going to be a waste of my time and your time to talk about it. But I'm here to discuss my own personal experience and my understanding of what this concept of jury nullification means, okay? This is basically how the law looks at it and looks at attorneys who are trying to maybe, quote unquote, nullify a jury, which we'll get to as we are discussing this topic. Now, finally, before I begin, here's a warning to all potential trolls out there. I have 1, 2, 3, 4 moderators that are watching this chat very closely. So if anyone decides to troll, you will be taken care of. Okay, so please don't. I want to keep it civil. I really want a lively discussion. Don't forget, before I'm finished here, we will have Eric Brandt joining us, and we will have, I think this will be a lot of fun. So let's dive right in. Jury nullification, what is it? As I always start with a definition so we all are on the same page. It's basically a concept where members of a jury in a trial find a defendant either not guilty or maybe not liable if it's a civil case, if they do not support the government's law. It doesn't mean that they simply rule one way or the other if they think the evidence supports. They ignore the evidence in its entirety and simply what's called nullify. This is why it's called jury nullification. They nullify the law. They basically say, you know what? I think that this person did it, but I don't think this law should be law. Maybe it's unconstitutional. Maybe we don't like it. There's some classic examples from history that we will touch upon. So if they don't believe it's constitutional or humane and do not support the punishment for breaking said law. I remember, I think in California back in the 70s, believe it or not, this is true, look this up. There was a law that said it will be illegal to be ugly while walking down the street. Okay, so imagine being charged with something like that and then having a community having to decide whether or not you've actually violated this law. I mean, just completely barbaric. Leave it to California to come up with something so unique, right? I think in West Virginia, it's actually still law in the books to, you are forbidden from flying a black flag. Black flags back in, historically, some of you may know, meant we shall never surrender. Okay, so I don't think anyone has ever enforced this law. I don't know, because a lot of U of L fans here at the University of Louisville, Cardinal fans, they have black and red attire. But regardless, finally, there was one law in Kentucky, actually here, I remember about an ice cream cone. You could not have an ice cream cone being carried in your back pocket. Now, why was that? That was a way for people to steal someone else's horse. The horse would follow the ice cream cone, and then you know, that's how people were able to steal other people's horses. So anyway, where does it happen, or where can it happen? It can happen, as I said, in both civil and criminal cases. In a criminal trial, a jury nullifies by acquitting the defendant, even though they believe that the defendant did indeed commit the alleged offense, but they don't believe that they should be charged with the breaking of it. The law should not even apply. They can also convict if they disagree and they think this is kind of reverse jury nullification. Happens a lot less and is a lot more rare, but it is possible. Where can it be applied? A jury verdict that is contrary to the letter of the law pertains only to the particular case before it. So whatever the facts are in that particular case, the jury will nullify that particular verdict in that particular case. It's not something that can be applied to as a law. Now, there is a caveat, and I might as well just dive right in. Historically, for instance, prohibition laws, about 60%, I've read, about 60% of cases that were brought on people violating alcohol laws at the time, the juries would simply acquit, even though the law said alcohol is forbidden to be possessed, consumed, sold, etc. Juries would simply say, well, we don't care, and they would acquit about 60% of people that were committing the offenses, and eventually the government. There's the belief that the government was kind of almost forced to repeal prohibition because it just wasn't working anymore. People were so against it. The general public, I think this is pretty much almost what's happening with marijuana at this point, as we can see. But regardless, that's why the majority of cases, marijuana cases, at least in Jefferson County where I practice in Louisville, you will never see someone going to jail for it. I mean, we're talking just a slap on the wrist. It's a fine, right? And most places are like that, except some outlying counties. So a jury cannot, and this is the key here, why it's such a sensitive topic, a jury cannot, by law, be instructed to question the law or decide what the law says. There is an exception. There was one case, I believe, in 1865 I found in my research, where the judge actually instructed the jury on this, but that was the only historically that I could find a concrete example of a judge actually instructing the jury on this issue. But later on, as we will learn, I think I probably am getting my dates wrong, so feel free to do your own research on this. But there was a case that eventually we'll say that we'll get to that says that you are, as a judge, you are not permitted to instruct the jury on jury nullification premises. So another example, by the way, is the Fugitive Slave Act that was passed. Not too familiar with it, but essentially the premise is if you were assisting in runaway slaves and you were being prosecuted for it, people would simply just acquit. They refused to assist the southern colonies in convicting individuals who were helping slaves reach their destination, which where they're all going to the north. Another example is, don't forget that each jurisdiction is different, by the way. Florida, for instance, juries decide guilt or innocence, and then the judge decides the punishment. Whereas in Kentucky, the juries decide everything. So that is kind of crucial where the jury nullification comes in, because in theory, you could have a situation where the jury does not believe the person should be punished, but they think they should be convicted. Like in Kentucky, for instance, I've had a situation where a jury convicted my client of DUI, but then gave 0 jail time and gave the minimum fines and court costs, minimum suspension, everything. In Florida, that would not be the same. If a jury thinks that they should be convicted, for example, and they would convict, they don't decide the penalty, and then the judge could impose, hypothetically, the maximum penalty, whatever it may be, 30 days, 60 days, 100 days, a year, etc. So where do they come from historically? Where did this jury nullification concept come from? Apparently, this goes all the way back to the 12th, 13th century in English common law courts. Juries were composed primarily of laymen, because women didn't serve on a jury until probably the 70s. This is a total guess, I'm sure, because men have dominated juries for millennia. So laymen from the local community would serve on juries, and it was an efficient means to dispute resolution. The general power of the juries to decide on verdicts was recognized in the English Magna Carta of 1215, which put into words existing practices. No free man shall be captured and or imprisoned or diseased of his freehold and or of his liberties or of his free customs, or be outlawed or exiled, which was huge in those days, or in any way destroyed, nor will we proceed against him by force or proceed against him by arms, but by lawful judgment of his peers. Okay, there it is, 6th and 7th Amendment that we have. Or by the law of the land. So for a trivial offense, a free man shall be fined only in proportion to the degree of his offense, and for a serious offense correspondingly, but not so heavily as to deprive him of his livelihood. In the same way, a merchant shall be spared his merchandise, and a husbandman the implements of his husbandry, if they fall upon the mercy of a royal court. None of these fines should be imposed, except by the assessment on oath of a reputable men of the neighborhood. There it is, the oath that we will take, subject to direct and cross-examination, presumably. So the problem with that was, and the courts quickly realized, in the 13th, 14th, 15th, 16th century, there was a lot of jury tampering going on, and I think they called it packing the jury. And sometimes, even if a jury didn't give the judge what they wanted, they would simply issue a false verdict. The judge will rule that was a false verdict and issue a new panel. Okay, something that we would never see today, especially with the concept of double jeopardy. As you can see, our forefathers really foresaw a lot of this, and they put in fail-safes to prevent that. So if a second jury returned a different verdict, that verdict was imposed, and the first jury would be either imprisoned or fined. I mean, good God, right? I mean, I'm talking, we're talking sanctions for the first jury that ruled not the way that the court wanted them to rule, meaning probably to discourage future disobedience. Now today we have, by juries, now today we have laws such as jury tampering and jury intimidation, which are both felonies, at least in Kentucky, by the way. So if you participate in that, you will be looking at least a year in jail. So there are a lot of exceptions, not a lot, excuse me. There's a few exceptions to the historic jury nullification concept that I've been able to find. In essence, we'll not really dive in. I thought about going through them. I don't think it's going to be really beneficial to anyone. You are free to do your own research. But essentially, for a lawyer, for an officer of the court to argue jury nullification has kind of been unheard of for centuries. But they did try it in the 16th and 17th century, basically stating that the law violated runs contrary to morality, runs contrary to what we believe is right, and therefore you, ladies and gentlemen, or excuse me, you gentlemen, should acquit. Now, let's fast forward to the United States. Jury trial practice in the United States for several decades since the founding of the United States, apparently, it is my understanding that it was not permissible per se. Maybe it was frowned upon, but it was still in existence. It was still used, but it was not as common, obviously, for obvious reasons. The majority of laws most people agreed upon. I mean, I would venture to say with confidence, about 98, 99% of laws most people kind of agree with. It's that 1% to 2% that are sometimes historically changed, such as prohibition, slavery, or sometimes juries just simply may not be in agreement that a law should be a law. For instance, drug possession is the classic example, as we have even, forget marijuana. I mean, going back historically, I'm sure there were examples where there were some juries that acquitted, maybe even without being told the concept of jury nullification, because, as we will learn, back in 1839, there was a case called Stettinius versus United States, in which the court has held, and defense can argue law to the jury before the court gives instructions. And then judges began to demand that parties submit motions in writing before the jury is impaneled to be argued without the presence of the jury. This is called motions in limine. This is in practice today. I do these in most trials. This is to exclude evidence on which it was felt the jury would not hear argument because they were informed of the evidence to be excluded. So if, let's say, there was a motion in limine filed, or limine, some people pronounce it differently, if a motion in limine was filed and one of the attorneys were violative of that order, then the opposing party could declare a mistrial, and everything stops, everybody goes home, we pick a new date, and you start over on that new date. Now, the attorney who was in violation of the motion in limine would be sanctioned. The typical sanctions are money or even incarceration. Now, it's extremely rare. You have to go rogue, basically, in order for a judge to put an attorney in jail over a violation of a motion in limine, or even a standing order. You have to really, really want to end up in a cell. And even if an attorney somewhere out there has gone to such lengths as to get that, especially with something like jury nullification, again, I don't. Most attorneys just don't touch that concept because it is very sensitive, and in most cases, it just is not applicable for the most part. And where it is applicable, you create a strategy. You say it without saying it. I've never had the experience, but I'm sure there's some very classic examples that you can use. Jury nullification first appeared really in the United States before the American Revolutionary War. Colonial juries frequently exercised their nullification powers, principally in maritime cases and cases implicating free speech. Basically, British prosecutors gave up on trying to try them because they would lose so many of them. Same as I talked about the Fugitive Slave Act, Prohibition. Now, the interesting thing about, I think this is it right here, 1865. There was, or did I delete this? I'm sorry. No, okay, here we go. So post-Civil War, by the way, the classic example, white defendants accused of crimes against blacks were almost always acquitted, sadly. I remember from my education, the classic example of Emmett Till, who in a grocery store, he was a young kid, 12 to 14, whistled at a white woman, and her husband and his friend or brother or something like that, they beat him up and killed him and threw him into the river. They were arrested under suspicion of killing Mr. Till, young Till, and his body was found. He was maimed brutally. I mean, it was just a disgusting case. And what happened was the jury acquitted. Almost, I think it took them like 10 minutes to deliberate. There's a classic phrase from one of the jurors. They said, "We would have reached a verdict sooner, but we were going to get pop," meaning soda. And the two men actually received $5,000 each to give a story, since double jeopardy basically prohibited them from being prosecuted. This is a classic example of jury nullification, right? By the way, I think I forgot to mention that, but they both got $5,000 for their story to the newspaper, and they said exactly how they killed them, where they took them, what they used. I mean, the whole thing. Look it up. Emmett Till, Emmett Till, Till. Sick story. But that's an example of jury nullification, because there were 12 white men deciding the fate of 2 white men over the death of a 12-year-old black boy. Okay. In the 21st century, there are many discussions on jury nullification that center around drugs and drug laws. There is an advocacy group that estimates about 3 to 4% of all jury trials involve nullification. Hung juries may be another hidden classic example, maybe, of a jury nullification scenario, where at least one juror, 12 Angry Men style, maybe not able to convince the rest of the troop that they should acquit, or maybe vice versa, and they simply cannot pull that one, because in criminal cases, in most jurisdictions, juries have to be unanimous. Some states are 11-1, 12-2. I think 9-3 is an extreme example. Maybe Oregon is the only one coming to mind. I could be wrong, but feel free to look it up. And now here's the judicial opinion. Okay, in 1895, in the case of Sparf versus United States, Justice John Marshall Harlan, the United States Supreme Court, held 5-4 decision. This is as split gets, folks. 5-4. They decided 124 years ago that a trial judge has no responsibility to inform the jury of the right to nullify laws. So what does this mean? That means that 124 years ago, 4 judges wanted our court system to allow juries to understand that they are permitted to nullify the law. And 5 of them decided that they do not want judges to nullify the law. And that meant that became the law of the land. So that's interesting. I mean, that means maybe there could be a shift at some point. Obviously, we would have to reach all the way to the Supremes. We would have to have the perfect, I would say, case that would allow us to get that far. But maybe there is room for improvement, because my personal opinion, I'll just insert it right here real quick. I think juries should know, not in all cases. I mean, let's get real. But in some cases where it's merited, the jury should know from the court, coming from the bench, because that is where anything that comes from the bench of the juries take as the word of God. Okay, this is speaking from experience. This is speaking as an attorney. This is speaking as a human, as a civilian, whatever. Anything, any words, any statements, anything coming from the bench during a jury trial is like the word of God. So if the judge says you are free to nullify the law, which happened in 1865, I think is what I mentioned. 1895 was when this law was passed. The judge is not, it's not that they're forbidden, but that they have no responsibility. Now, it kind of evolved into forbiddenness, and maybe that should be changed. I mean, this is what lawyers do. We change laws. Back in the 30s, it was legal to euthanize. I'm sorry, not euthanize. What was it called? When a person can no longer reproduce. Oh my God, I'm blanking on this. I'm sorry. Regardless, it was permitted to do so in sterilize. Thank you. Sterilize individuals. It was legal to do so by chemical means or physical means. In the 1940s, we had Japanese internment camps. That was the law of the land. Now, it later changed very quickly with an apology by the Supreme Court, but it happened. So there are barbaric, chaotic, insane, draconian laws that have been passed and then nullified, right? There's that word. So in 1895, we have, as a court at least, we have an example of where 9 judges decided that one way. Maybe now it's time for a change. Who knows? I don't know where society is headed, but by the looks of it, I think, this is again my personal opinion, I think there are cases that merit juries to know that they are permitted. It's not just a guilty, not guilty. It's not just looking at the facts blankly. Now, we'll get to what can a lawyer do and not do in a moment. But essentially, in 1988, let's fast forward here, almost 100 years, over 100 years, excuse me, the Sixth Circuit went so far as to uphold a jury instruction that there is no such thing as a valid jury nullification. That was the Sixth Circuit. Then the Second Circuit in the United States v. Thomas in 1997, just 22 years ago, ruled that jurors can be removed if there's evidence that they intend to nullify the law. So during jury selection, if you realize that a juror is just not going to follow the law, that is a strike for cause, meaning you have an unlimited number. If every single juror raises their hand, I don't believe this should be law, boom, they're all out in the Second Circuit. So the Supreme Court has not recently been confronted with this issue. It hasn't gotten that far since 1895 in my research. In 2017, the Ninth Circuit upheld the first 3 sentences of the jury's instruction and overruled the second half. Basically, I don't have the case citation here, I apologize. But basically, the final sentence is, there's no such thing as valid jury nullification. You would violate your oath and the law, this was 2 years ago, if you willfully brought a verdict contrary to the law given to you in this case. I mean, that is miles and miles further than what the court said in 1895. The judge has no responsibility to inform the jury of the right to nullify. You would violate your oath and the law if you willfully brought a verdict contrary to the law given to you in this case. I mean, talk about extreme, right? So, I mean, that's what evolution does in the legal system. So, again, maybe it's time for a change. I don't know. Because the court deemed it harmless error and just affirmed the conviction on other grounds. So, the courts will always take the easy way out. Now, state laws. In 2002, South Dakota voters rejected by a 78% margin a state constitutional amendment to permit criminal defendants to argue for jury nullification. That was 17 years ago. In 2012, New Hampshire passed a law that explicitly allowed attorneys to inform juries about nullification, but 2 years later they said, we changed our mind. The Indiana Constitution states that the jury shall have the right to determine the law and the facts. So the law as well. Note that determining the law is another phrase for nullification, but it doesn't require informing the jury of this right. So just our neighbor to the north, maybe you have a little bit more leeway there. So in my own personal experience, as I've said, it's a really rare situation to encounter. I've never had a situation where it was merited. This is going to be Eric's ground here in just a few moments. Because most of my trials, nearly all of them actually, have been DUIs, driving under the influence. I would be hard-pressed to find a jury that would agree that it should not be law, that people should be allowed to get intoxicated and then get behind the wheel. It would never happen, okay? I may be an idealist, but I'm not a utopianist, okay? And that's just insane. Nobody would want that to be law anyway. The roads would become the most dangerous place to be on the planet. So regardless, moving on. Now, I have been able to convince juries after they've convicted my client, or I like to think that I convinced them, to issue the minimum penalty, which basically means beating the offer, essentially with either no jail time or minimum fine, etc. Believe it or not, it is considered a victory. So if you have a prosecutor, for example, the classic example is the prosecutor who wants a conviction for murder, and he's going for 20 years to life, or possibly even the death penalty. And the jury convicts, right? So that's a loss, right? Well, wait a minute. They issue a verdict, they issue a sentence of 5 years to serve. In Kentucky, the person would do 85% of that, and they'll be eligible for parole. That is a huge victory, death or 5 years, or maybe 20 years and getting 5, looking at 20, getting 5. So in my situation, as I've experienced, if the prosecutor's final offer was, let's say, 10 days or 20 days or 15 days or 5 days, and you end up getting 0, that's a win, even though you still lost and they convicted, okay? So finally, before we dive into Eric Brandt, can we talk about jury nullification in the courtroom? The answer is no. This is the 1895 decision. Can I, in the courtroom, say, ladies and gentlemen, here is the law. You're to decide guilt or innocence, but you have another option, by the way. Ignore the law. That's a no-no. I will probably get sanctioned for it the first time I talk about it. It's too simple. I don't need to explain. So in criminal cases, what can an attorney do is, rather than go for nullification, and this is what I do, I have my clients testify. They take the stand and they tell their story. And if I think they're innocent and they shouldn't be convicted, I think that they should talk to, because that's exactly what we're doing in the courtroom, explain the situation, the videos that you've seen, to 6 men and women to decide, with the exception of that one case where I had 6 women, which was phenomenal. It was so random. Ladies of the jury. I've never had a chance to use that phrase, and maybe you won't get a chance again for a while. I cannot say the words, you may nullify the law or juries may. It's just not permissible and very, very, very sanctionable in American courts. Now, again, as I've said, my client can testify, and if the jury, through hearing what they have to say, believe that whatever penalty or sanction is requested of them in this case should not be imposed, they can simply vote not guilty. Essentially, what one would call nullifying. Hypothetically, imagine a scenario. Imagine a county in Kentucky where they're imposing the maximum jail time for possession of marijuana. Now, this is an extreme, and I have actually seen counties not that long ago. I don't think most of them don't do it anymore, but some of them used to, where they would, on simple possession of this much weed, I think I talked about it in one of my videos, they ask for 14 days in jail. I would try that case. I'd probably try it for free. The whole trial would take 15 minutes. I'd have my client take the stand. Yeah, this is my own personal stash. I was smoking that. Okay. Well, what are they going to? They're going to convict. Fine, whatever. Who cares? He's guilty of it. It's the law. He's not. I mean, I don't think they should be, but hypothetically, if it's a very conservative county, they would convict, and then who in their right? I can't imagine a human being that would lock somebody up for possession of this much marijuana. You know. So at the end of the day, if an attorney mentions, or an attorney, by the way, notice I've said not somebody representing themselves, because a pro se litigant, meaning a person representing themselves, which I don't ever recommend. Not because I want your money, okay? I want people to understand it and make this absolutely clear. As much as I would love to have you as a client, that's not the point of me personally. Some lawyers may disagree. It's extremely risky and dangerous for you to go inside the courtroom, not knowing the rules, not knowing the law. You can study and study and study and study as much as you want. I believe me, and some of you will do that. But the problem is the system frowns upon that, and they don't take you seriously, even when you are completely prepared. I've seen it personally, and forget the whole sovereign citizenry and all that. There's a special instruction that the judge has to read to you. It's very condescending. It's almost like they look at you like you're an outsider, and it's sad because maybe your case really is winnable indeed, and it's just better to have someone who knows the rules and knows how to play by the rules to allow you to overcome that threshold of getting what you want, which is walking out of there not guilty, an innocent person. Okay, so that's just important for you all to understand where I'm coming from. So now I've been talking for almost 40 minutes here, and I want to turn this over to Mr. Brandt. He, by the way, just a couple of words about him. I've watched some of his videos. He's a very interesting character. I don't know what he's about to say. He knows the topic. I have not prepared him. I hope he's going to be as informative and as interesting as I hope. He's the only person, by the way, this is very fascinating. He's the only person that I know of in the history of my life, let alone career, that has been kicked out of jail. How in the world do you get? Well, here's what happened. I think out of about over 100 times he has been arrested, he has been only incarcerated once or twice, is my understanding. Don't quote me on this. But he has one time actually been placed in jail, and he just started teaching the other inmates as to how to fight their case, what they need to file, how they need to file it, what language they need to use. And the people just got tired of it in the system. They just kicked him out of jail. I mean, that's pretty badass. I've never heard of that happening anywhere in the history of my entire life. And I don't know if he's alone in this, but I'm sure he will discuss it if he so chooses. So let's get Mr. Brandt on the line. Let me know if you can all hear that, by the way.
Hello.
Hey, Eric?
Oh,
Eric, can you hear me?
I can hear you.
Okay, Eric, this is attorney Larry Forman. We discussed jury nullification with the people here on my stream. I don't know if you have been watching, but people are saying that that they can hear you. So, if you don't mind, would you just enlighten everybody to your own personal experiences with jury nullification and how that came about in your life?
Well, I don't know if I'm qualified to answer this question since I've only faced 7 felonies for distributing jury nullification literature and made case law on the question, but I'll give it my best whirl. What would you like to know about it?
Well, how did you use it? Let's start with a simple question. How did you use it in the courtroom?
Well, interestingly enough, I did win a case with jury nullification, and it was after my jury nullification arrest. In the city and county of Denver, it is a crime punishable by up to a year in jail and a $1,000 fine to sit down on the ground. This is part of the anti-homeless laws. Well, I objected because I see this law as used to get rid of the blight on their blingy 16th Street Mall cash register, which is about a mile long, very densely populated strip through Denver that they do a lot of commerce on. And they don't like homeless people there. But what I see it is, it's a way for them to look through a person's last belongings, rifle through their things. And all you have to do is be traveling through, see a group of people that look like they may be travelers, sit down at the tables that are provided for people to sit at, but not have enough chairs, and sit down on your duffel bag instead. And now you're getting arrested. And I think it's unjust. So I took a giant 6-foot-high box out of the dumpster. I wrote Acme Cop Catcher Kit on the back, KKK Cop Catcher Kit. And then on the front, I put a smiling kid's face, and I wrote Police Appreciation Day free donut. I put a donut underneath it, propped it over the stick, and sat down behind it with a string. And they came by and told me that I have to stand up. And I said, I'm not going to stand up unless you arrest me. And so they filled out some paperwork. Said, are you going to sign this? I said, sure. I stood up to sign it, and I said, this isn't a citation. This is a warning. Well, we have to do this first. I said, well, I told you were going to have to arrest me. Well, we have to do this first. I said, can you tell me that if I sign right here and sit my happy ass back down on the sidewalk, then you're going to arrest me? He said, yes. I said, okay. So I signed it and I sat down. So go to trial, and I took the stand in my defense, and I told my jurors, I said, I have to apologize to you because you have to find me guilty. The reason why you have to find me guilty is because the culpable mental state that the prosecution has to prove, and they've certainly proven it, is knowingly. And I went beyond knowingly. It was my intentionally designed scheme to be arrested and put in front of you today. And here's why. Because it's an unjust law, and either you're going to make this decision, and I'm going to use this decision to pressure the city to fix a bad law, or you're going to find me guilty. And I'm going to use that appeal process to stress the city on this law. So I told you have the power to find me not guilty because you agree with me it's an unjust law, or find me guilty, I'm going to appeal it. They deliberated not 1, not 2, not even 3 or 4, but 7 long, grueling minutes, unanimously not guilty.
Interesting. So if I hear you correctly, basically we have a law that is trying to almost outlaw homelessness. And since you can't outlaw a physical state of being, they created a law that forbids a person from sitting around, effectively targeting the only people who would be in that category, which would be the homeless. And then you presented that law to the public, saying this is to a very narrow public, but the public nonetheless, 6 men and women in a courtroom. And you told them, I'm in violation of this law. I did this knowingly, willingly, intelligently, voluntarily, etc. And therefore, you should find me guilty because I'm in violation of this law. And essentially, you have two options. One, you're going to find me guilty, and I'm going to appeal it, or you're going to find me not guilty, which will urge a change in the system.
Yes, that was the intention of the work. Yeah, and at this point, what I've accomplished is that as I'm the only one I know of that's allowed to sit down in the 16th Street Mall. I've laid down in front of their vehicles, the police vehicles, and shouted, "I'm in violation of 38-86.1, and I demand my immediate incarceration," and they won't bother me about it. And I've done that for like 20 minutes at a time. So I've achieved the ability to sit down on the ground, which is somewhat disheartening, but they will still arrest other people for sitting down on the ground. We've seen that many times.
Right. So here we go. Again, I'm just reaching out to my viewers. This is another example. We've talked about slavery, prohibition. Here's another one. Homelessness. Homelessness is another very critical problem. I think that would it be fair to say to target people who are homeless is just not just and not fair?
I think that we could all agree that it is a substantial question of great public concern. Whichever side of the fence we're on, I think it's irrelevant. But yeah, it's a question of great public and social concern. And it's my belief that these 12 laws called the Denver Urban Camping Ban are abusive and they are unjust. That's my opinion. That's what I lobbied against. And I absolutely advocate for jury nullification as it comes to social injustice, for crimes of being alive.
Do you have any other personal examples?
We've had a lot of cases that I think it's possible that the jurors may have elected to nullify, but we don't necessarily know. That particular case, I can tell you with certainty that it was nullification because I absolutely told them they had to find me guilty. And
they chose to go the opposite way.
And they went the opposite way, yeah. So what I can tell you is that I was able to hold some numbers. It was a couple years ago that I did this work, so my numbers are qualitative at this point and not precise.
Wait, hold on, Eric. 1 second. People are saying that they're having trouble hearing you. Let me see if I can adjust something here.
Maybe me as well. I need to go outside because we don't get the best signal over here. Let me try and relocate.
Yeah, we're gonna have to work technologically if we do this again. I apologize to my viewers, but this is the best I can do. And we've been planning this for a few days, so I just don't have the technology.
Is this a little bit better?
Okay, people are saying this is much better.
Okay. So what happened in 2015 was that I convinced my friend Mark Iannicelli to go out to the courthouse with me and distribute literature published by the Fully Informed Jury Association in Helena, Montana. I've been an admirer of the jury nullification concept and wanting to do more of my part of government by the people. I wanted to distribute and educate jurors about this important information. And Mark asked me, he says, we're not going to get arrested for this, right? This is all legal, right? And I said, oh, for Christ's sakes, Mark, don't be ridiculous. It's protected speech. And besides, what prosecutor would ever put the very document in all of our jurors' hands as evidence, which certainly they must do if they were to arrest us for this, it tells them that they can nullify the law. They're not going to do that. That's ridiculous. So we distributed literature one morning, and while I was inside helping a woman clear a warrant, I came outside and they were arresting Mark, and they charged him with 7 felony counts of jury tampering. And I was outraged by this. So I emailed the district attorney with exactly this phrase: "What the fuck is wrong with you people? I handed out at least as many flyers as Mr. Iannicelli, and I demand equal justice under the law. You must also charge me with 7 felony counts of jury tampering." And of course they did. So there were other activists, including the Fully Informed Jury Association, and here locally, Eric Verlo and Janet Matson. Janet Matson's a name you recognize because she's the woman that feeds the homeless on the 16th Street Mall every week. and they filed a lawsuit in federal court wanting to distribute jury nullification literature, but feeling afraid that they would be penalized with felony arrests if they did. And the court granted a preliminary injunction and said that the courthouse plaza is a free speech zone 24 hours a day, 7 days a week. Well, being as that we're people of like mind that are standing up against the abuses against the homeless community, we thought, well, 24 hours a day, 7 days a week, we moved in and we occupied the courthouse for 57 straight days and nights. So despite the preliminary injunction, they did raid us almost nightly. We have 36 raids. Sometimes there would be 12 of us on the plaza overnight, and they would come in with over 100 law enforcement to raid us. And there were 24 arrests, and I was personally 9 of those 24 arrests. So we go through this prosecution process, which took, a year and a half essentially to go through this. So we continued to distribute jury nullification literature in the mornings when they had jurors. They rescheduled juries to try and make it harder for us to do that. They did make it harder for us to do it. They were absolutely beside themselves. And then now we're going through the court process, so we're there frequently enough that we could continue doing this for quite some time very effectively. And so then I pulled some statistics. And what I hope to encourage people to do is to distribute jury nullification literature. And if you are arrested for jury tampering while doing it, you may be able to find benefit in citing the people of the state of Colorado versus Eric Brandt. Because so far, the courts have consistently upheld our actions as free speech. But what kind of effectiveness does this kind of a campaign have? Well, prior to 2015, there were approximately 40 trials per year, jury trials per year in the 3 general sessions courts, and they had an acquittal rate of approximately 17%. So out of all them people getting arrested in Denver in general sessions court, which is, over 2,000 tickets written a year, only 7 people were found not guilty by juries. Nearly everybody is found guilty by pleading guilty. So 40 trials, 17%. I was anticipating that the data would show an increase in acquittal rates, and it did. In 2015, the acquittal rates were 41%. We were out there for half of that year. In 2016, where we were still pretty strongly present, it was 38%. And in 2017, it was down in the high 30s range again. Now, what I didn't anticipate was that our work out there would encourage more lawyers and defendants to take their cases to jury trial.
Which is, at the end of the day, which is, I think you would agree, is the goal, and I'm fully advocating for that as well. I think we have kind of, and feel free to disagree with this, I think the concept of the jury has been kind of buried and lost upon us with all the deals that have been happening, that we need to revive that concept and use it a lot more frequently.
Right. So, and this is what was very encouraging to us, is that the data also showed, so in prior to 2015, they were running about 40 trials in 3 courtrooms per year. So it's, just over 10 trials per courtroom per year. And in 2015, there were 70 jury trials. And remember, we were only out there for half of that year. In 2016, there were 99 jury trials. And in 2017, there were 104 jury trials. And in 2018, they opened 2 new courtrooms.
Mm-hmm.
And so I don't have new data for the 2018 year yet. But their response was not to, we saturated the court. They just could not do more than 30 trials a year per courtroom. And they were working, not only were they doing 3 times as many trials, but now all of a sudden, their acquittal rates skyrocketed. They more than doubled. And so that's really like a 500 to 600% increase in the prosecution's workload. And what was happening is that they were dumping cases left and right on speedy trial. They just could not get them in. And so it kind of forced them to make decisions on petty crimes versus legitimate crimes of violence or property injury.
Mm-hmm. Let me address a couple of questions here, Eric, and then I'll get back to you. John Barry asks, what would happen if I, as a juror, asked about jury nullification in court? That's going to be a very interesting scenario, John. I honestly think the judge would either have the judge would either have to instruct the whole panel that they're probably not permitted in accordance with 1895's decision, or they would maybe have to scrap that entire panel and start over on a new day, because
I've seen them scrap a whole panel before. What's interesting is that when you first begin to saturate a jurisdiction with this literature, the first thing that is going to happen is that they're going to try and push you back.
Of course.
And when they realize pretty quickly that that can't happen, then the next thing that they're going to do is the prosecution will bring up jury nullification during voir dire for you. And, the defense cannot bring up jury nullification.
Okay, here, let me address this. This is right on point, and I think people are actually noticing this. And this is crucial for people to understand. Boomer asks, would jury nullification work in a trial against a violent offender with a past history of violent offense? And let me say right away, probably absolutely not. Again, people in their mind need to understand what jury nullification is about. It's about cherry picking unjust laws that should not be in the books, that make no sense, that are either hypocritical, stupid, whatever it may be. That's what jury nullification is. Unjustly applied, maybe unfairly applied, that sort of thing. It may be
a perfectly legitimate statute, but it's not being properly applied, right? So the community can say, okay, it's a crime to paint your sidewalk any color other than purple, but fuchsia really is close enough to purple that we're going to let it slide.
Exactly.
Right? So, and I mean, Casey Anthony was acquitted by jury nullification.
It's very possible. And
and she murdered her child, chopped the body up, and hid the parts in the woods. So you may be thinking, why would a panel of 12 jurors acquit Casey Anthony? And if you watch the interview that they made in tears a year after they agreed to stay in silence for a year, but in the Casey Anthony trial, here we have a big case. It's a big high-profile case. There was absolutely zero question, not just beyond reasonable doubt, there was beyond no doubt. There was absolutely no doubt.
Well, hold on. Now, be careful, Eric. And again, I don't want to turn this into an argument. My own personal opinion on the issue is that they did not believe, much like in the O.J. Simpson trial, the jury did not believe that there was enough evidence that the prosecution showed with it beyond a reasonable doubt that the person is guilty. So I would caution to call that nullification per se, because nullification, the jury did not argue that the death of a child killing a child is a bad law. It was more along the lines of
that was a good law.
Insufficient evidence.
What they didn't appreciate was the way law enforcement handled the evidence, and they were concerned. Their premise was, there's nothing we can do to bring the child's life back, and it's a tragedy. There's a reasonable chance that she may, in fact, be suffering from a severe mental illness, postpartum depression. And if that is the case, then what penalty is going to stop her? She's going to be in a prison of her own mind for the rest of her life, no matter what. And they were very concerned at how the police mishandled the evidence in the case. And they basically made the decision that they had to pass on to their progeny a system that was in at least as good a shape as they received it. And in order to do that, they needed to tell law enforcement that they too have to follow the rules. And if they're going to mess up such an important case, then what more injury are they committing at the paper cut level?
Eric, I want to shift gears and talk very briefly. I'm sure the viewers already alluded to this, as you're the only individual in my entire life that I've known getting kicked out of jail. If you don't mind, just very briefly talking about, first of all, how did you land? What landed you in jail, and why did they kick you out, and how?
So I'm going to go out on a limb and presume that you're talking about the Great Sidewalk Chalk Paper of 2014.
Let's assume so.
Okay, so Westminster and I were having, that's Westminster, Colorado. I call it Waste Monster. They spell it Westminster. We've been having this battle, this issue. This all started basically because of Westminster. And they were in my home again without a warrant again, and it pissed me off again. And then they racially profiled my dearest friend by coming to my house and saying, that we have reports of an unauthorized black female on the property, and that was like the last straw for me. So I demanded an internal investigation, and they responded to it. By the way, the same officer in this incident is the very officer that has been denying public records and been hiding evidence in the Timmy Henley death recently, and that would be Commander Dean Polano. And he responded to my demand in writing. He said, I have no desire to fill in any blanks on what occurred. So I decided that I wanted to fill in the blanks, and I found a big blank piece of sidewalk in front of the mayor's office, and I filled it in with chalk. I drew an 8-foot-wide pot-bellied pig on its back, crying into a big puddle of tears, and I emblazoned it with 2-foot-high letters, make a pig wail and you'll go to jail. And of course I did. So that got me processed as a sidewalk chalk criminal. And ironically, that particular arrest, I did get dismissed after a year and a half of prosecution. But there were other chalk incidences. I've been arrested for chalk 8 times. And so and the next chalk incidences, 2 of them, were in the same year, a few months later. The differentiating factor here is that I had liquefied the chalk for easier application, and that convicted me, and I lost the appeal process. So I was sentenced to 90 days for writing on public sidewalk with chalk. And in that process of the appeals going through, the officer that had arrested me for the Great Sidewalk Chalk Caper of 2014 was brand new to the department at the time, had just been fired from another jurisdiction after a lawsuit, a neighboring jurisdiction, but was brand new to Westminster. And by the way, I was arrested by 9 cops in that first incident. 9 of them took me to the ground for chalk. And so even though I actually prevailed on that particular case, there's still linkage here. Curtis Lee Argenbright is the officer. In the meantime, Curtis Lee Argenbright is transporting a woman from the hospital, and it's a courtesy ride. He takes her to a dark street. He makes her take his pants down. He handcuffs her, and he commences to have sexual intercourse with her. And he's so brazen that when he finally drops her off at home, of course telling me not to ever tell anybody about it, flips her his business card and says, call me sometime. Okay. Well, she was traumatized and she didn't stay quiet about it. And they prosecuted him, and he took a plea deal. He was charged with felony sexual assault by a person in a position of trust. He took a plea deal for misdemeanor sexual assault, and they sentenced him to 90 days. So the cop that arrested me for chalk, for which I got 90 days, raped a woman in uniform and got 90 days. We were actually in jail at the same time.
Okay, so in jail, that is horrific. That is horrific. How did you get out of jail? That's what I think we're more interested in knowing.
Well, I was practically given red carpet treatment to leave the jail. There are a number of things. For one thing, I try to make it my practice to file at least 3 grievances a day. And of course, then they don't respond to them, and I just keep piling on more paperwork. But I don't stop there. I certainly encourage others to file grievances, and I encourage others to use the law library resources and learn about their cases, because nobody cares about your case more than you.
Exactly.
And your lawyer's never going to bring you steak dinners to the jail.
The biggest mistake that I think people have is when they go to the courtroom, naturally, people look up to somebody, and who is the somebody that approaches them first is the prosecutor. And even though the prosecutor has absolutely zero interest in the person, the person going to jail, the person going to the courtroom looks up to them. And a lot of times they will say, I can't give you legal advice, just to kind of explain to them. But the problem with... Yeah,
but people don't understand what that all means. Right. It's a problem.
Exactly.
Right?
And the problem is that they earn a certain level of trust with this prosecutor who doesn't care about their case. All he wants is a conviction. And that's why, I encourage people to hire an attorney, of course, because we know the way around the system, especially a good attorney. But I also encourage the ones who have, just like you, if you have the time, the energy, the desire, by all means, learn your case, learn the law backwards and forwards,
I don't see how you could not have the time and energy, right? Because
people who are working, 7, 8, 9, 10 hours a day may not have the same liberty as others. Is basically what I'm getting at.
That's a true statement. That's a true statement. But these are matters of great personal and familial concern, as well as great public concern. And so I always encourage people to learn about your case.
Right.
I don't make the decision about representation until I've seen my discovery.
Of course.
And I will not enter a plea until that point. And then I usually take representation. For one thing, I don't have a law library. I don't have LexisNexis access. I don't have a paralegal, and I don't have an investigator. And so I would usually take legal counsel, at least for those services. You can always fire your lawyer at trial and do your trial yourself if you're so inclined. But I cannot advocate the pro se way. My experience as a pro se defendant is mixed. But I can't advocate letting your lawyer do it either, because, quite frankly, my performance using a lawyer is also mixed. And
I understand completely.
Yeah, so I tell my lawyer, listen, we're a team. I am your expert advisory witness. You are my legal advisor. And if you can't handle that, then you're off the team. I'll get another lawyer. I'm no longer willing to tolerate crappy lawyers.
Holly Wire, by the way, asks, if you can't afford an attorney, will the court appoint one for you? Usually, yes, especially if it's a crime that carries a penalty of jail. But nearly all jurisdictions, if it's just a traffic offense or anything that does not carry a jail sentence, or maybe is a minor enough infraction where there is a jail sentence, but they simply don't, they don't give people, like the most classic example is failure to maintain insurance on your vehicle. There is a minimum 30 days jail, a maximum 30 days jail on a first offense, 90 days on a first, 180 days on a second. Nobody ever imposes those unless there's probably a death or something, because it simply would make no sense. So in a lot of insurance cases, even though there is jail time potentially, there's not a prosecutor in the universe in Jefferson County that will, or maybe even in the state of Kentucky that I know of, that would impose that sentence. But listen, Eric.
Well, it sounds like Kentucky's a little more progressive than Colorado in that regard. But otherwise, I mean, for the most part, what you say there is something that I would totally mirror here. In these minor cases, traffic infractions, I never get a jury, and they never get a lawyer.
Now, Eric, listen, I hate
to... Traffic offenses, on the other hand, are different.
Eric, I hate to cut you off, but do you have any closing remarks on the concept of jury nullification to our viewers?
Jury nullification, as I believe Thomas Jefferson said, is the only device ever created by man which can successfully hold a tyrannical government in check. And this is very important. The Fugitive Slave Act was ended because jurors would not convict runaway slaves. Prohibition was ended because jurors would not convict alcohol charges. And the civil rights movement was effective because, for the most part, jurors would not convict activists. And we've seen a lot of cases where we believe jury nullification was at play, but we don't necessarily know. I know I have one that was. We've seen an increase in acquittal rates of minor cases. And again, minor cases, keep in mind, we're not advocating for lawlessness here. We're advocating for check and balancing law enforcement and prosecution. We're advocating for holding the government in check. Government by the people only works when the people find cause to stand up and participate in it. And as jurors, you are the most influential person in the world, and the words "not guilty" are the most powerful 2 words that could ever be uttered by that influential person. Your voice is way more important and powerful in the jury box than it is at the polls. And so advocating for educated jurors, for fully informed jurors, I think is the most noble cause that we have in our country. We're having a liberty crisis, and I think that's the most noble cause at the moment. Is educating the public on what government is and what juries are all about.
Thank you so much, Eric. I wholeheartedly agree. Thanks again for joining me, and I hope that you have a wonderful rest of your Sunday, okay?
Thank you very much. I look forward to seeing everybody in Beaver, Oklahoma this week.
Okay, then. All right, Eric. Bye-bye.
Thank you, sir.
No problem. Bye-bye. All right. Well, there you have it, folks. As promised, thank Thank you all. Okay, New Hampshire. Somebody mentioned here that my state is the only state that does not require auto insurance, and it turns out that it's New Hampshire was the answer. So I actually did not know that. The other 49 states require auto insurance. I wonder why that is. Is it because they never passed it, or I don't know. Now I'm curious. I'd like to learn this. And I'm not going to pronounce your name, but it's something to do with a dinosaur, Saurus. Are you licensed in Ohio? No, but soon. And I have an attorney that's going to be helping me practice. I want to break into the state of Indiana, which I already have. And next up on the list is going to be Ohio in the coming months, followed by Tennessee, and then probably Florida. I have my sights set because there's just, it's such a very liberal state. I'm really looking forward to practicing there. Idaho needs you. I'm sure I'm needed in a lot of places, guys, but I'm only one man. There's only so much I can accomplish, at least at this juncture. I am looking for a second associate. I wish I could have this beautiful face work for me, but unfortunately, she hasn't gone to law school. I've been trying to get her off her butt to start studying for the LSATs, but it's no go. Every time I tell her to study for the LSATs, she just barks at me. So I don't know if you guys can find a way to put her through law school. I will definitely love to have her on the team, but she provides emotional support. So love my doggy. Her name is Beady, by the way, to some of you who may be wondering. So, I mean, there you have it, folks. Straight from the horse's mouth. It is a way, as Eric said, it is a way to keep, a jury nullification is a way to keep a tyrannical government in check. I'm not calling our government tyrannical, but if it's not kept in check, as any government is wont to do, they would start going out of control. They would start passing laws that should not be laws. So the first line of defense that we have as a nation is juries, plain and simple. The community decides, do we convict or acquit based on the evidence provided? The officer said this, witnesses said that, maybe the defendant testified and said something else. What's our decision? Do we have sufficient evidence that this is beyond a reasonable doubt, a conviction, or is this an acquittal? Not guilty, right? Or innocent, one of my favorite words. So the second line of defense is if the law that was passed is an unjust, unreasonable, tyrannical law, or simply a law that time has done away with, such as we discussed slavery, possession, drug possession. So times having changed, laws becoming antiquated, nonsensical, useless, meaningless, prohibition, another thing, then the people, as even Eric said, the people react. The people stop convicting. And one of the reasons that people stop convicting is because they don't believe that should be law anymore. And they show the government, hey, this doesn't work anymore, fix it or stop it, whatever you will, however you want to look at it. So that's their second line of defense. So the first is has the law been broken? And if so, should they be punished? And the second line of defense is, oh, this shouldn't be a law anymore anyway, or this particular law should not be law, period. Something like that. So that's pretty much it, folks. I'm looking to see if there are any questions that I may have missed. If you all have, do you need a paralegal? Dogs are better than people. Yes, Mitch McKenzie, I agree. They love unconditionally, and I love them back. Do you need a paralegal? I do not need a paralegal. I need an attorney, actually, here in Kentucky. So if you all know anyone who wants to practice law in Louisville, Kentucky, send them my way. Colorado leads the nation in jury nullification, maybe due to Eric's work. Who knows? Do cases, Obtuse One asks, Larry, do cases in other commonwealths have the same weight as a case decided in your state of residence? No, they're not. there's a word, of course, I'm not going to remember it right this second when you ask that, but essentially they can be considered, but they're not law. They do, other jurisdictions do not have to follow law of jurisdictions that are not them. So one state does not have to follow the law of all other 49 states. Sometimes they look at it as instructive, but it's never mandatory. And we're one of few, I think there are only 7 commonwealths in the country, and the rest are states. So anywho, thank you all for joining me and Eric and Beady here today. We thank you all for coming. We thank you all for joining us. Like, comment below, subscribe to my channel. I really hope that you all have enjoyed this very, very special episode. I will begin streaming every week, Sunday at 8. You all have voted. I listened. So 8 o'clock evenings on Sunday. I really hope you enjoyed this. I've had a lot of fun. I had no idea what Eric was going to say. Of course, we got a little sidetracked there, maybe for a minute, but I hope we've all learned something today. So once again, thank you everyone for participating. Thank you to my moderators. We got Modified Mommy, The Liberty Cause, Dragonfly One, and Pajama something. I'm so sorry. She didn't comment recently, so I did not see it. It's Pajama something. Thank you all for moderating this. It's 8 o'clock Eastern. Yes, Genevieve. 8 o'clock Eastern time every Sunday. And the next topic, I believe, is going to be suppression hearings and probable cause and suppression hearings. And we will see you all in the next episode. Bye, everybody.